everybody! Happy Maniac Monday, people! How we doing? Are we ready to get served? It's your boy Phil. How we doing? Wow, what a day for court. I didn't know what to record next. Bing, 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 bing. And not to mention, my girlfriend's back. Looking prettier than ever. How we doing, people? See the poll? Is McNally next? And I see in the comments, Rich, Hessen hasn't been posting either. That's why I'm scared. Because she's in that 33rd District Court also. So either they're both on vacation or they both went. And we are finito. Let me get to my second order of business. Irish Demon. My man. He is unbelievable. I just crossed paths with him in the chat. I think Peach was in there. A couple other people were in there with me. We were chatting. And then he goes, I'm a big fan of your channel. I was like, what? Dude, you got like 50,000 subs, bro. And then he was like, then today out of nowhere, I just said hello, popped into his live. I'm always in his live. I really don't chat because I like his content also. That's what I knew he is. And he just went off on a tangent on how good he likes the channel and the community and all that sort of stuff. It was so cool. So if you haven't checked out Irish Demon, which you probably all have, just go check him out because we are doing something together. Which leads to number 3. Thursday is Mikey the Legend making his appearance from Credence and Mikey Show. He's coming to hang out with us on Thursday. Going to do some court clips. Hopefully we got a car chase. So that's going to be unbelievable too. So Thursday, we're going to have some fun with Mikey. So, I know you're all here to see me, but let's play some clips. And OMG, poor Judge Washington today. I played Chester Bell before. Do we remember Chester Bell? His first appearance, I played him on a live. It was his second appearance today. Let's roll.
Bell 22S00909 as well as 22S00951.
Rachel McDuffie for the people.
Assistant Public Defender Timothy Carey, I can rule your honor on behalf of Chester Bell. Mr. Bell, can you state your name for the record?
Chester Bell.
Thank you. Good morning.
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 All right, we're here for a pretrial today.
I believe so.
Correct.
Yes, Your Honor. So Mr. Bell has been on our docket for quite some time, and I think that on his first appearance on the docket, with me being on the docket, I had indicated to the
Monica's back.
I wasn't prepared to really address a potential offer until we sort of sorted out his bond violation status to figure out, he was hospitalized for a while. So I just didn't have a clear sense of where he was and what type of things we needed to account for within an offer. Since that time, we've gone back and forth a bit more with that, where Mr. Bell was required to report for his scram tether, and the court ordered him to get a 10-panel drug test in that same day, but he was unable to get the scram tether and said that he was once again in hospital. So I don't think he ever did get that 10-panel, if I'm not mistaken.
Actually, what
Mr.
happened?
Bell. Let her finish.
Sorry.
So he may have. I'm just saying that I don't at this point I don't have a current, I guess.
So if you didn't see the part 1 where we had Chester Bell, he was complaining that he had to put the scram and he had to pay $11 a day, and he was just coming up with all kinds of excuses to not put the scram on. He just got back from the hospital. Judge Washington was not having it. She gave him enough chances, and if we all know Judge Washington, she gives a million chances. She is unbelievably fair. So when she had enough with you, you've exhausted all of your chances. So now we have part 2 where the prosecutor, Miss McDuffie. By the way, we have come to the conclusion that she is Prosecutor Angela Bassett because she looks like Angela Bassett, basically. So she's saying that this is the first time with him and he still hasn't done the scram or whatever. So here we go.
Sense of where things are. So given that, I'm kind of right back where I was in terms of needing to get a better sense of what the status is here. So I do not have an offer prepared for Mr. Bell today because we're kind of still coming back with him coming back from the hospital.
So, I mean, I think she's correct. He never got the 10 panel done.
I did, Your Honor. The
You
same
did?
day I got my tether.
He's such
And
a
they
slob.
said that if you don't hear from them, then you pass. And I never heard from them. And that was on you know what? I don't think I have the date exactly available, but I've been wearing this tether now for like about
Looks like
a
April 4th.
week and a half or so, or something.
Agent Casey emailed us and said that Mr. Bell reported for a scram. The email was on April 4th, so somewhere around that time, but I just
Well,
don't have an updated report.
There was one day that I come in, they told me to come in to get the scram. And I went in there and the computer wasn't working. So they couldn't do my tether. And so he asked me to come back the next morning. And so I did. And I came back the next morning before noon is what he told me. So I come in about
I'm not
11.
talking, sir.
Yes.
We're not talking about the scrim right now. I want to know if you got the panel.
I understand, Your
test
Honor.
done.
I understand, Your Honor. I'm just letting you know that the next day when I got the scram tether actually put on successfully, then I hung around until I had to use the restroom, and then I provided the sample. And I never
Thank you.
received a call back.
Okay, one
and-
second, Mr. Bell, please.
Yeah. Sorry.
Miss Straub, are you there?
He's such a slug.
Morning, Your Honor.
Good morning. How are you?
How are you?
Good. Could you tell me if you could check to see what his results were from his
I just pulled it up and it looks like he did test on 4/4, and it was clear.
Thank you.
Good job, Mr. Bell.
So what would you like for us to do at this time, Ms. McDuffie? Thank you so much, Ms. Straub.
Yes, thank you, Your Honor. So given that, I just, I need to sort of take an accounting of everything that has happened so far, to figure out. So I don't have enough prepared today. I am requesting an adjournment, and we can say that's on behalf of the people. But we kind of went around a bit with hospitalization, so we haven't really had them stable.
I try to be as compliant as I can with you guys. So to my knowledge, I've done everything that you've asked. So if there's anything else that you guys need, you can always just reach out to me, and I'll try to do it as fast as I can for you. That's all I can do for you.
I'm not accusing Mr. Bell of anything. I'm just saying he's been ill and not been available.
No,
So-
I'm just letting you know that I'm trying to
Mr.
comply,
Bell,
and in the
Mr.
future I
Bell,
will.
Mr. Bell,
Ma'am,
please stop.
I was just trying to be supportive.
Mr. Bell,
Supportive. He said supportive. What? Can't with Bell.
how long do you need, Ms. McDuffie?
Just 2 weeks, Your Honor, at the most.
Any objection, Ms. Kyriakou?
No objection, Judge.
May 1st, 2023 at 9 a.m. Bond is continued.
What's up, people? Amazon. We have a lot of new people. Hey, Amazon girl, my member.
See you on May
One of my
1st,
newest
Mr.
members.
Bell.
How you doing?
May
What's up, Steph?
I
Michelle's back. Grim's
check my
back.
calendar real quick? I might have a doctor's appointment. Is that all right?
Yes, sir.
Okay, I can do it right here on my phone. Just give me 1 second.
He's like Debbie Downer from the Saturday Night Live. Just male form. Chester Downer. I got a tether. But then he's got like finger tats and stuff.
Okay, that's me.
Was he like undercover gangster with an Urkel voice? Was Chester running the streets? Chester, check your calendar, dude. It's not that hard. Oh God. Yeah, what's his schedule? Not drink, court, watch Netflix, walk to the pantry.
Hmm?
Look at him. All doctor's appointments. Dude, really?
Well, Your Honor, I may be wrong, but I think that date is fine.
I'm so glad it's good for
Okay,
you.
thank you, sir. We'll see you then.
She can't get off
Sorry
the phone
that
quick
I
enough.
got on your nerves.
It's okay, Mr. Bell. Have a good day.
All right, you too. Bye.
Bye-bye.
That was fantastic. Look, she likes him. I love Washington. She's the best. We're gonna roll right into the next one. Here we go.
Mr. Simpson, are you there?
So we're used to Judge Simpson, the GOAT. This guy is the jackass. Oh my God. If Washington could take her hand and grab someone and yank them out of Zoom, it probably would have been this Simpson from Michigan. So let's roll. What's up, Daylight? Rebecca, my crazy's here.
Mr. Simpson.
Can you hear me?
Shaquille.
Yes, sir. Please state your name.
Joshua Simpson.
Thank you. All right, we're here for a review in this case. It's your first review, sir. It looks like you're doing what you're supposed to be doing. You've got 29 sessions in so far in the domestic violence classes.
Yeah.
Dog issues.
Are you learning anything in those classes, sir?
Yeah, I'm learning a lot.
Maddie, get out of here.
Stop dealing with certain females.
Oh, wow.
Yeah.
That's the only thing you learned in that class?
I mean, basically, if
You didn't learn anything about yourself in that class?
I mean, yeah, but I'm just saying, like, mostly, like, stop dealing with certain females that get you in trouble, you know?
Did your own behavior have anything to do with you getting in trouble?
Yeah, it did, but it wasn't just me. It's always two people. It always takes two people. You know what I'm saying? So, but I know it was my fault for being in here.
Well, I can tell you, you're a first. I don't think I've heard anyone say that since I've asked them how the classes are going and what they're learning.
Cause I mean, I still.
How many classes do you have there?
I think I got like 56, but it's just like.
No, that's how many you have to do.
Right.
Yikes.
Hopefully, by the time you get to like 40 something, you'll say something different when I ask you this question and mean it.
Even lie, dude.
I mean, I'm saying I'm learning a lot, but it's just like just stop dealing with certain females that's going.
Well, the fact that you're even saying it that way is problematic. Certain females.
Yeah, I mean, we talk about a lot in that class. If you would have took the class, you'll understand it.
Huh.
Huh.
Wow.
Yeah.
Which class is he in? I'm not certain he's learning anything in any of these classes.
I am learning.
I must be one of those certain females,
Nah,
based on the way you're talking to me right now.
no. You taking it the wrong way, man.
No, I'm taking it exactly how you said it.
Okay.
Awkward silence. How hot is Nina, by the way? Oh, I'm gonna hear that one in the comments. Not the chat, the comments. Oh.
You also haven't been making any payments on your fines and costs. When can you start doing that?
I was on probation. I was on probation at 2 other places except for this one. Well, in this one, so that was 3. I just got discharged last Friday from one of my probations, so I had to pay them off.
That answers the question of what you did before. Now, my question was, when can you start making payments?
I don't know. I don't have a job right now. I haven't had a job really. I broke my arm in 2007.
You paid off a different probation. You haven't had a job, but you paid off a different probation.
Can I finish, ma'am?
You can answer my question.
What's the question?
When can you start making payments?
I don't know. I don't have a job right now.
All right. I want to see you here in person.
Oh my God.
It's a kiss of death. This guy is a goon.
May 1st, 2023 at 10 a.m.
Oh.
In person.
We'll be there.
See if you can answer my questions at that time.
He's in trouble.
I answered your question.
You want to be held in contempt today?
I'm just saying, you just said I can answer your question. I answered your question.
Sir, come here on May 1st, and we'll see if you
All
have
right.
the same too. Ypsilanti Township.
Slow clap for Washington. Yikes. Oh, cut the tension with a knife. He is screwed. See you on May 1st. Mr. Simpson will be there. All right, next up. Oh, God, there's just so much. Let's go to Judge. Let's see. I'll surprise you. How's that? A little surprise. How's that? Look who we got. Look who I got. There she is. My girl. This was a good one.
So let's include this case on the mix. Ms. Stevenson, the order that you submitted, did it have this case number on it?
It does, Your Honor. It has 20.
I mean, I'm saying this case number. I mean, it has all the case numbers. When it should have, the order applies to all of the case numbers. So let's get it over to the jail for all of the case numbers.
I definitely have one for 2304-408-901, and that was what our motion would have been to the court, is to just let me submit motions for bond reduction for every. But they should have the one that's keeping him in jail. I would also tell the court that Mr. Wilder does have a detainer from the Michigan Department of Corrections, Your Honor, but his understanding and his representation to me is that if this court does grant GPS tether release, that they'll lift that detainer.
All right. Well, I thought I granted it, but I'm definitely granting it. So go ahead and send it over, Mr. Flanagan, and
okay.
And then he should be able to get released. Now you got a lot of places you can't go to though, Mr. Wilder. Okay.
Yes, ma'am. I understand that, ma'am.
Now, Mr. Wilder, you're innocent until proven guilty. Let me say that first. You're innocent until proven guilty. So I'm not suggesting that you're guilty. You're innocent until proven guilty. But I just want to share with you that did you know that you share a last name with an individual attorney who used to be on our Michigan Court of Appeals and Michigan Supreme Court?
No, ma'am, I did not know that.
Yeah, I don't know if you all are related in any way, shape, or form, but I know that at least your names, the last name carries some, some greatness in it. I want you to, if you are guilty, I don't know. Right now, you might, well, Mr. Edward, he might be saying, no, I know he's guilty too. I don't know. But right now, you're the only one that know if you're guilty or not for sure. I don't know. But if you are, I just want you to do better because we can do something. We can change some things around no matter what age we are. We do some stuff that we look back on and be like, that was dumb. Why did I do that? We can move forward. But I just wanted to share that with you that we used to have some Michigan but he was Michigan Court of Appeals then. He was Michigan Supreme Court, and you all had the same last name. His first name was Kurt Wilder.
Oh,
look him up. Y'all might be related. You'd be like, I got to do better because I'm out here, doing this on the name, and he over there doing that on the name. It kind of bring us in the middle. Let's go. Okay. Anyway, all right, Mr. Wilder. Yes, Mr. Wilder.
I just want to, is there anybody that I can apologize to, Mr. Edward?
Oh, not yet. Don't apologize. Yeah, your lawyer don't want you to. She don't want you. But she'll talk to you. She'll talk to you and let you know when that might be appropriate, okay?
Yes, sir. Yes, ma'am. Right. Yes, ma'am. Thank you, ma'am.
All right, you're welcome. Okay, now so they should be letting you. I don't know anything about that detainer.
Oh yeah, I'm not worried about that.
Okay, we're going to correct the order, and then if they lift the detainer, then you should be leaving. Pretty soon you should be leaving today. Okay.
Yes, ma'am. Thank you, ma'am.
All right. Mr. All I done messed your name up 3 times. So, sir, with respect to the July 17th date, you don't have to come. I'm talking to the complaining witness. You're not required to appear. However, if you want to appear, you can feel free to do so. As a complaining witness, you may appear at all the court hearings. However, you're not required to appear. And if you don't appear, you can contact Miss Ritter, and she will let you know the next court date and when your appearance is required. Okay, sir?
Okay.
All right, then you're all set. You have a great day. Stay safe.
Thank you.
Mr. Wilder. Mr. Flanagan,
I don't know why she got so nostalgic with that judge. But she was like in her zone. She had to tell that guy could give 2 fudges about appeals court Judge Wilder. He just wanted to get out, and she just won't be quiet. I love her. So that was one side of Bryant, and this she doesn't erupt, but this is a good one.
A little confused.
Okay.
So you're saying, well, never mind. Don't let me be confused. Let me just bring them in. I guess they're on the same device, but they put it under the defendant's name.
Yeah, she said that she was renamed.
Look at this guy. Is he crazy? Does he have a death wish? He must have not gotten the Judge Bryant memo. Oh my God. He's got a security. What is up with those shades? Oh my God.
No, they're not. I mean, they're not. Okay. Okay. All right. All right.
Good morning, Your Honor.
Hold on, please. Hold on, please. All right, the gentleman, Mr. Howard, I'm not sure what's going on, but you need to take off your hat, all of the things you have on your head, you need to take those off. And then I'm going to send, well, as soon as you come back in your camera, sir, I'm not sure. All right. You have a lot going on. All right. And then I need you, and the gentleman on the Samsung, please accept to join Okay, Mr. Howard, you need a place where you could be in private, because the person that's behind you with the cover on them laying down is disrupting court.
She's late.
Okay, all right, well, all right, hold on. We can't have the people behind us going to bed while we in court. All right, please accept to join the breakout room and then remain in the breakout room until they.
I told you I had clips. Okay, ready? Oh boy. Thurston and SeaTac never disappoint, and they did it again. Why do you think Time Served recorded this one?
Ma'am, did you have a question? No, he hasn't been presented yet, so you didn't miss it. All right, sir, over in the jail, what's your name, please?
Christopher Thayer.
Someone got the...
All right, is that Thayer?
Yes, sir.
Okay. And Mr. Thayer, today you're in court for a preliminary hearing on an allegation of violating the domestic violence law. Did you have a chance to talk to Mr. Sneva from the Public Defender's Office before court?
Yes, this morning.
Okay. Mr. Sneva?
Thank you, Your Honor. At this time, we'll enter a stipulation to probable cause for the purposes of this hearing only. We would ask to be heard on conditions of release and to be screened for an attorney. Currently, he does not have an income, Your Honor.
Can't even see, never mind work.
All right, Mr. Thayer, I'm going to appoint the public defender to represent you in this case. All right, and Mr. Denawi, what's the state's position on release here?
Your Honor, the state is recommending that bail be set at $10,000. And there are no contact orders with either one of the victims, the wife or the son, and no contact with the dog that he attacked. But the state is also adding a count of DUI due to the fact that one of the witnesses that he had an altercation with noticed that he had been driving erratically and appeared to be under the intoxication. And when the police officers came across the defendant, they too noticed that he was under intoxication.
Okay.
So now, if you listen to his charges, did he get his ass kicked before he got arrested? That's what led to his arrest? Or did he get his ass kicked in jail? Sounds to me like he was in a fight and he was intoxicated and got his ass kicked. But I don't know. So, there's really nothing else going on with this case. I just wanted to show you Rocky Balboa / Post Malone. Good one, Rick. All right, here we go. And here we go to SeaTac. Our West Coast court nerds know all about this. They are the late afternoon brilliance. And we got another one from SeaTac from Judge Rhea Perlman. And here we go.
Can you unmute yourself? You know how to unmute yourself? It's the little microphone button with the slash through it. There we go. Hello, Mr. Hans.
Good morning. Good morning, Your Honor.
And Your Honor, this is Mr. Leif Vidar Austin Hans, and that's case number 3A0.
Not to mention that he has his bifocal. His bifocal. But he's got. Did you hear his name? Listen to his name.
172224.
Good morning, Your Honor.
And Your Honor, this is Mr. Leif Vidar Austin Hans, and that's
Leif Vidar Austin Hans. I can't.
Case number 3A0172224. And this is an agreed guilty plea.
He holds his monocle.
Mr. Hans, I have a document here entitled Statement of Defendant on Plea of Guilty. Towards the bottom of it, on the line that says defendant's signature, there's no signature there. Have you not signed it yet just because you had no way to sign it?
You can't see the damn thing.
Correct.
If you had had a way to sign it, would you have signed it?
Yes.
SCORE will give you a chance to sign it after this hearing. Do you promise to sign it at that time?
Yes, ma'am.
When you reviewed this form with your attorney, did he read it to you? Did you read it by yourself? Or did you read it?
No, he read it to me.
Of course he did.
And was he able to answer any questions that you had?
Yes.
As I review this form with you, please stop me at any time if you'd like to ask him another question, okay?
Yes, ma'am.
Is your true and correct name Lance Vidar Austin Hance?
Yes.
And you're 47 years old and have completed high school?
Yes, ma'am.
You're pleading guilty to the crime of criminal trespass in the first degree. Do you understand the elements of that crime? In other words, what the city would have to prove if you were to take this to trial?
Yes, ma'am.
By entering into this plea, you're giving up a number of very important constitutional rights. Among these are the right to a speedy and public trial, to remain silent during that trial, or to choose to testify, to see, hear, and question witnesses who would testify against you, to have witnesses testify on your behalf at no expense to you, to the presumption of innocence unless and until a jury were to find you guilty, and to appeal a finding of guilt. Do you understand you're giving up all those rights?
Yes, ma'am.
The crime of
He's 47. I missed that. I swear the comment. You guys are the best. You guys are the best.
criminal trespass in the first degree is a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine. Is that your understanding?
Yes, ma'am.
I know your attorney and the city attorney have an agreed recommendation, but the court does not have to follow that and can sentence you anywhere up to the maximum. Is that your understanding?
Yes, ma'am.
Do you understand in the event you're not a citizen, a guilty finding on this charge may be grounds for deportation, denial of naturalization, or exclusion from the United States?
Yes, ma'am.
Did anyone make any promises to you to get you to enter into this plea?
No, ma'am.
Did anyone make any threats to get you to enter into this plea?
No, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
In paragraph 11, there's a statement that reads, on April 13th, 2023 in SeaTac, Washington, I did knowingly remain in a building when I remained inside the Hampton Inn on 19445 International Boulevard, SeaTac, Washington, without permission and did not leave when asked to leave. I know your attorney wrote that statement, but do you adopt it as your own statement?
Yes.
Is it a true statement?
Yes.
As to the crime of criminal trespass in the first degree, how do you plead?
Guilty.
I will accept the plea. I do believe it's knowingly, voluntarily, intelligently made, and there's a factual basis to support it.
Chili.
Ms. Chenweller, anything to add to the sentencing recommendation?
It is an agreed recommendation. Defendant has 5 days credit for time served. City's requesting conditions including no contact with the Hampton Inn at the address listed, include the warrants listed within 30 days. I did put a proposed May 17th date in there, but certainly the court can do whatever it deems fit.
Thank you. Mr. Pujer-Tudan, anything to add?
I would just ask that you follow the agreed, court follows the agreed recommendation, Your Honor. I would also be asserting Blazina based off my client's current housing situation.
Are they just making up words now? His name is definitely not real. What's Bazina?
And income. Thank
And
you.
does he have 5 days credit?
Yes, he does. He has 5 days credit. He was booked on the 13th.
That his plea could say, you have been found guilty of murder. You will be executed tomorrow night in SeaTac. Do you agree? I think so.
Mr. Hance, is there anything that you'd like to say?
No, ma'am.
I'm going to follow the agreed recommendation. I think it's appropriate given the nature of this charge. Do you receive any government benefits?
Just food stamps.
Sentence will be as follows: 364 days in jail with 359 suspended, 5 days credit for time served. So you'll be released on this case today. $5,000 fine, all 5,000 suspended as I'm making the finding that you're indigent by virtue of the fact you receive government benefits. So there'll be no fines, fees, costs, or assessments associated with this charge. And
I love how he's got the one eye closed. I can't.
there's nothing mandatory. Jail time will be concurrent with any other holds, and the court is taking 24 months of jurisdiction. For the next 24 months, you need to attend any future court appearances, have no new criminal law violations, no contact with the Hampton Inn at 19445 International Boulevard in SeaTac, and within the next 30 days, clear the warrants in Whatcom, Chelan, District Courts, and Bellingham Municipal Court.
Oh, God.
And do you still receive mail general delivery in Bellingham?
Yes, ma'am.
Perfect. If once you do get an address, and I sincerely hope you do, please call the court, okay?
Yes, ma'am.
All right. Thank you, sir. I wish you well.
Thank you, ma'am.
Thank you, sir.
Help him out.
Next.
Thank
Drop him
you.
off at Lenscrafters. Poor
You
guy.
can give the iPad back to the guard now, please.
What? I had an iPad? Where? Okay, here we go. Oh boy. Teen heartthrob of SeaTac. Yo, man, I shouldn't even be here. Oh, dude. Here we go.
Good morning. You ready?
Yes, this is Tyler Dalton Druitt, 3A0350889 here for arraignment.
Hang on. Let's look at that. Also, there was another case for Mr. Perez that's on tomorrow for pre-trial, out of custody, so we're adding that.
Okay, sounds good.
I think it might have been arraignment. I have to look at it.
Was it arraignment? Okay. But in any case, hasn't been addressed. It's still pending.
Okay. So proceeding with the arraignment for Mr. Druitt, is your true and correct name Tyler Dalton Druitt? You can answer aloud so the court can hear you. Is your true and correct name Tyler Dalton Druitt? You have to answer aloud so the court can hear you. 1 second. Is your true and correct name Tyler Dalton Druitt?
Yes.
And your date of birth is April 23rd, 1996? Yes. Earlier we went over your rights to arraignment. Did you have any questions about your rights I wasn't able to answer? The form that I gave you. You put in your sock. Did you have any questions about the rights that we went over?
You didn't say anything.
The right. 1 second, Your Honor.
Dude, you didn't say anything, bro. Lisa, time server, the only thing more interesting than these hilarious court cases is the fantastic chat. Yes, you are correct, ma'am. The best chat on LawTube. And Kitch, too, because it's the same people. What up, Kitch? Dude, you didn't tell me my rights, bruh. Oh, stay tuned for this one.
And Mr. Druitt, do you have any questions about your rights at arraignment? You have to answer yes or no.
Why do I have to answer?
Because
He went, mm-mm.
the court wants to make sure you understand what your rights at arraignment are.
I understand. You've asked me like 5 times.
Okay.
But sir, he hasn't asked when I've been listening. And I need to know that you know your rights at arraignment.
Yes, I do.
Okay, thank you.
I've gone over the charges, the maximum penalties, any mandatory minimum penalties. We acknowledge issue the complaint, wait for more reading, and absent or plea of not guilty. We are asking for a direct appointment on this case.
Plea of not guilty will enter. I do find probable cause to detain, or I did rather yesterday, and will direct appoint. What is the city's recommendation regarding release?
Given the lack of history known to the city and the part of the defendant at this time, the city has no objection to release with standard conditions, including no contact with SeaTac International Airport without legitimate travel purposes.
Any objection?
There's no objection to those conditions.
I was just looking at the docket on the felony. I don't know if the parties have had a chance to look at that.
What felony? Okay, you guys let me out of Everett for this.
What's up, Steven?
You guys let me out of Everett for this.
What's up, Dan?
No, I was in Everett for this, and you guys let me out.
I have no power to let you in or out of Everett.
This is from Everett Police Department.
So it looks like there may be a competence evaluation pending.
No, this is literally from Everett Police Department.
No, this charge right now.
No, the felony that you guys accused me of and lied about in court.
I'm not, sir. I have no idea what's going on there. I'm not a part of that. That's not in this court. However, I'm just looking at what's happening there. I'm not accusing you of anything. I'm not doing anything.
You can try to get a copy of that.
I just wanted to draw the party's attention to that. Okay, sir, so I'm going to release you on your promise to appear, which means you have to come back to court on the following conditions: that you attend all future court appearances, have no new criminal law violations, no contact with SeaTac International Airport or the rental car facility. So unless you have a ticket to fly somewhere, you cannot go back there. And update your address with the court and DOL immediately if there are any changes. And the address we have on file is on 7th Avenue Southeast in Everett. Do you still receive mail there?
He said no, he doesn't currently have a good address.
I'm supposed to have a driver's license there.
This guy sucks. No way, he's no.
And we'll set this on for an out of custody pretrial hearing on May 16th at 8:30 in the morning in SeaTac Municipal Court.
So they released you on this case. This is a separate case than what's going on in Everett. This is out of SeaTac. So you're gonna have another court date in SeaTac. Okay? It may be that we need to get a hold of that evaluation because that could get this case dismissed potentially.
You're not muted, just so you're aware, Mr. Hernandez.
Yeah. I'll mute, but
I'll see if we can get a copy.
SeaTac never disappoints. Never. Awkward breaks. Could you imagine when he's talking to? I would love to be a fly on the wall. Dude, this is Everest. I'm telling you, they charged me with a felony. I'm not saying yes. You suck. They had bologna for lunch. I really wanted salami. I'm out of here. You suck. All right, here we go. Mr. Braunlick. Ooh, look at this winner. Ooh. I told you I had a ton of clips today, people. Ton of clips today.
This is not Mr. Leiter's client. Okay, is this Mr. Leiter's client? Okay, I just saw him there. All right.
Oh, where did Mr. Duval go?
He left.
Good morning, 6. For the record, this matter is before the court. Mr. Duval apparently have been arrested on a bench warrant issued by this court at the request of the front of the court. It appears that Mr. Duval is appearing from the Monroe County Jail. Sir, are you Michael David Duval?
Yes, sir.
What's your current address?
3043 Lewis Avenue.
3430 Lewis Avenue.
3043 Lewis Avenue.
3043 Lewis.
Yes, sir. Yes, sir.
Is that Temperance?
No, it's Ida.
Ida?
Yeah, 48140.
Do you have a, Mr. Val, do you understand that you're being charged with civil contempt of court for failure to pay child support? It's punishable by up to 45 days in jail. Since it's possibly of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. You understand all of that?
Yes, sir.
Are you requesting a court-appointed attorney?
Yes, sir.
Do you currently have a court-appointed lawyer on any other matter?
No, not right now. No.
Okay. You were arrested over the weekend on a new criminal charge. Is that correct?
Yes, sir.
Are you also on probation?
Yes, sir.
When did you last see your probation officer?
I've never seen him.
Okay, so you've got a probation violation warrant as well as a new charge. Probably unable to post bond, is that correct?
Correct.
Right. Are you currently employed?
No.
When were you last employed?
About a year ago.
Sure.
Who supports you?
Well, I technically work, but I work under the table. I support myself.
Okay. All right, so who pays you under the table? What do you work for? I'm sorry?
Tree services that people I know. I'm not going to give any names.
Okay, do you have any money at home?
No, I've been living in hotel rooms, kind of, with my girlfriend. I go to bed. The address I give you is my dad's address, my living address, but I'm with my girlfriend most of the time. We stay at hotels and stuff.
So your girlfriend supports you?
No, we support each other.
All right.
She's here with me right now, so we're not technically supporting each other. We're in jail together.
Okay.
They're so lovely.
When were you did you last receive any compensation for any tree cutting service?
Week ago maybe.
Okay, is that money all gone?
Yeah. I have other children that are actually younger than Kyla, and I actually have involvement with. They didn't. Their mom didn't take them from me for no reason, and the courts didn't have to be involved.
Correct, Stephen.
All right, Mr. Duval, the court will grant your request for recorded appointed attorney.
Your Honor,
Mr. Masix?
the front of the court found Mr. Duval has a previous finding of contempt from November of 2015. It is a first finding, and he actually does have 35 days hanging over his head still from that first finding.
I'm sorry, I should have asked that question first, Ms. X. Could have avoided that. So there's no need for an attorney because there's already a contempt finding.
That's correct, Your Honor.
Right. Do you have any questions, Mr. Duval?
I do not, Your Honor.
Yeah, I thought I already did time for that. Why am I doing time for it again then?
You didn't serve all
I
of
was
it.
in jail for it. I was in jail in 2015 for it. So
Ms.
why
X,
is it
can you
being
explain
brought
that?
up? I need a lawyer. I don't want to. I'm not talking no more. I want a lawyer.
Ms. X, can you explain to Mr. Duval?
Certainly. On November 16th, 2015, you were found in contempt of court by this judge. It can mean up to 45 days in jail. Because of that, he sentenced you to 45 days, 10 immediate. He gave you credit for the 3 days you had served. And so you still had a balance of 35 days hanging over your head. If you were never to be in compliance in the future, the judge could always just sentence you back to jail based on that finding. And until you exhaust the balance of that sentence, we don't need to find you in contempt of court again.
Okay.
Once you do serve the full 45 days, a second or subsequent finding can mean up to 90 days in the county jail.
All right, my daughter she's an adult now. How do we make this go away?
You need to pay off the arrearages, sir, or you can ask the mother of the child to waive the arrearages. The only two ways it's going to go away: either pay it off, or it gets owed to the mother for the support of that child. So unless she can voluntarily waive it, if she chooses, that's her choice, or you need to pay them off, one or the other.
Man, how much do I owe? Does anybody even know?
The current balance is $3,659.93. It is now an arrears only case. The child emancipated in 2021. The last payment received by the friend of the court was June 28th of 2021 through income withholding.
So Mr. Duval, it's not tens of thousands of dollars like some cases, it's only $3,600. So
That's what I'm
you
saying.
gotta
I've
make,
always paid. I was always paying. I had a job. Wasn't like a deadbeat dad, other than her mom wouldn't let me see her.
obviously,
I mean,
you either did not appear for a review hearing or you were not paying support on a regular basis. That's why the bench warrant issued. You were ignoring the obligation. If in fact you have a financial difficulty, keep in contact with your friend, the court caseworker. That would avoid a bench warrant. If you say to the friend, the court caseworker, I can pay $10 a month or something, but you did nothing. Send your hands. So at this point in time, there's 35 days jail hanging over your head. But you've got obviously some criminal charge you need to deal with. Ms. Hicks, what's your recommendation this morning?
Your Honor, because he does have criminal charges, it looks like 2 violations of probation and 1 new felony charge. The friend of the court is not interested in eating up more of our time since he does not seem to be in compliance previously with payments. However, he was arrested yesterday on the 16th, so he would be entitled to 2 days jail credit. The friend of the court would not be opposed to doing a 2 days immediate credit for 2 and doing a short adjournment and requiring him to report to the friend of the court immediately upon his release from the county jail. He can pick up the jobs list and apply to however many jobs per week the court would like to order him to apply between when he's released and when we come back for a review.
All right, that sounds reasonable. What's your suggested adjournment date? 30 days?
30 days, Your Honor. I would be looking at May 16th at 10 a.m.
Follow the recommendation of Ms. Hicks, which is simply adjourn this matter, give you credit for 2 days in jail, which means you got 33 days hand over your head. So give you a chance to, once you take care of the criminal matters, go out and get a job. You need to find a job that's a regular job. You can't just work. If you're going to work on a table, that's fine, but you need to start making regular monthly payments.
Yes, sir.
Is there anything you want to say before the court imposes a sentence, Mr. Duval?
No, sir.
All right, the court follow the recommendation. Mr. Duval, you order to serve 35 days and work on jail as follows. 2 days immediately, you give him credit for the 2 days you have served. Balance of 33 days is reserved. It's hanging over your head. You're ordered to appear before Ms. Hicks for review on May 16th, 2023 at 10 a.m. A copy of this order will be emailed over to the jail. You'll get a copy of this sometime today. In the meantime, if you are released from the county jail between now and May 16th, you're ordered to immediately report to the front of the court to get a jobs list. We have a 4-page list of employers that are screaming for employees. I can get you a job today. Jack's Lawn Service. There's a lot of jobs out there. You can do a tree removal, branch removal on the sides whenever it's available, but you need to have a regular income, Mr. Val. There are a lot of jobs out there. In addition to pick up,
I love when Bronlick goes on a tear.
but jobs list, I'm requiring you apply for at least 5 jobs per week and provide written verification of your attempt to. There's a form that the friend court will give you. You need to have that filled out by 5 prospective employers per week until you find a job. You do that, again, I am confident you come back May 16th, you'll have a job. You got to pay this off, or if you have a relationship with the mother of this child, Brendan, Janice Danielson, maybe she'll waive your urges. But you got to pay these off. Do you have any questions, Mr. Duval?
No, sir.
Once again, you're not entitled to court-appointed lawyer because of their prior finding of contempt. This was simply reserved sentencing. So keep in mind, if you blow this off, don't do anything, and don't appear on May 16th, another bench warrant's going to issue. You got 33 days to have your head.
All right.
Now, I wouldn't impose a longer sentence if it weren't for the fact that you're in jail on criminal charges. I'm not going to waste up this time. I want to keep this hanging over your head to give you some motivation to take care of it.
Okay.
Any questions?
No, sir.
All right. This order will have all of this detail spelled out for you.
All right.
Guess who I have? Now, I was having a debate with someone that I watch court cases with. He's actually an actual buddy of mine that I work with. I got him on court. He was trying to tell me that Sallyport is better than the Wyandotte jail cubicle. I said, no way. Pound for pound, Wyandotte jail, there's more nutsos in that Wyandotte cubicle than Sallyport. Sallyport is a little overrated. They really don't have, like, nutsos. Wyandotte, Every time you see those 3 walls, and you're looking in on that 4th wall, there's somebody nuts on that other end. I don't care. Wyandotte is underrated. I'll take the cubicle any day of the week. Here we go. She's back.
GROAT.
Thank you. And please raise your right hand. You solemnly swear for the testimony you're about to give this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right. Thank you very much. And you may proceed on the warrant.
On Friday, April 14, 2023, approximately 11:17 p.m., Sergeant Gates and Deputy Chief Hamilton were patrolling the area of 2nd and Oak Street in the city of Wyandotte. Officers observed a vehicle traveling westbound on Oak Street without its headlights activated. Officers stopped the vehicle at Oak and 6th. As officers spoke with the occupants of the vehicle, they observed open bottles of beer in the cup holders between the the driver and the front passenger seat, and a 6-pack on the floor with 2 open bottles and a few unopened bottles. Deputy Chief asked the front seat passenger, Mr. Madero, to exit the vehicle and placed him under arrest for open alcohol in a motor vehicle. While Mr. Madero was exiting the vehicle, DC Hamilton saw the white particles on the seat where he was seated. While officers were placing him into handcuffs, he laid on the ground and acted like he was going to get sick. Once handcuffed, Officer Ames located a small baggie of field-tested cocaine in his front pants pocket. Again, cocaine was field-tested positive to be 1.5 grams of cocaine.
All right. Thank you. Upon examination of complaining witness, I find that the offenses charged were committed. There's probable cause to believe the defendant committed those offenses. And counsel, good afternoon. Your appearance, please.
Good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands muted.
Thank you. And Mr. Hernandez Medrano, your name, please, for the record.
Miguel Hernandez Medrano, Your Honor.
All right. Thank you. Thank you. And the court will waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. You've had an opportunity to speak to your attorney today. You're correct?
I hope so, Heineken.
Correct.
All right. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You have also the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Correct.
Do you understand those rights?
Yes, I understand them, Your Honor. Sorry about that.
All right. The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on April 27th at 9:10 a.m. And counsel as to bond, and then the court will hear from the detective, Sergeant. You're muted, Mr. Shemke.
I'm sorry, Judge. Yes, in this circumstance, my client is 35 years old. He graduated high school in 2006. He currently is a warehouse associate at RNDC. He lives alone in Southgate. He indicates he doesn't have any children. He will appear at any and all future court dates, so we'd respectfully requesting any leniency this court can consider when determining an appropriate bond. Thank you, Judge.
Thank you. And sir, I have a couple questions for you, sir, and then Detective Sergeant Grote, I'm going to give you an opportunity. Are you currently on probation, sir, for your matter out of the 28th District Court?
Can you repeat that?
Oh, Toby.
I'm a little bit hard on hearing.
I'm sorry?
I'm a little bit hard on hearing. I got like an earache, so it's a little bit hard for me to hear, but go ahead. Sorry about that.
Are you currently on probation or parole anywhere?
No.
He said he had an earache.
Did you successfully complete your probation out of the 28th District Court?
I can't.
I finished it, yes. I believe so. Yes, I finished it. That's Southgate, right?
Are you currently, yes. Are you currently out on bond in any other jurisdiction?
No.
Okay.
Stephanie.
All right. And Detective Sergeant Grote, your as to bond.
Your Honor, he's been a model prisoner since Friday. He's been here. He doesn't have that big of a CCH. Claims he wants to get some help for his addiction problem. 5,000, 10% is good with us to assure his appearance in court.
All right. And sir, you don't have a valid license, correct?
No, I have an ID.
Okay, so you don't have the privilege to drive, sir.
No, ma'am. I get back into work with a poll worker. So no, I don't have a valid license. I don't drive. I don't drive.
Your Honor, he was a passenger in the vehicle.
Yeah, I was a passenger. I'm not driving. Yeah, I don't drive.
All right. And
I missed that stamper.
The two defendants on that warrant right up. Defendant number 2 is charged with the suspension.
Oh, look at her white
got
out.
it, I see that, sorry. All
Use
right.
that white out.
And so, Mr. Hernandez Medrano, it appears though you and alcohol get into trouble together. You have a couple convictions you have a couple alcohol related convictions on your record, and now
Correct, ma'am. Your Honor, it's like I was telling the detectives, it's been an ongoing struggle. The past year, I've been fighting it. I've been going to detox. I was just telling them that like last week, I just set up a psychiatric specialist with substance abuse, and it's gonna be in May 11th. I'm working with a therapist that specializes in substance abuse right now. The reason I'm doing all this is I got this job that it gives me the chance. It gives me great insurance, so I could seek these help. It's an ongoing process. I've got my ups and downs, but I'm actually putting the effort. I'm losing sometimes, but I have more wins than losses. And I understand where you're coming from and where you're saying, but I'm trying to build a team where that's why I got the psychiatrist, because I feel like it's just not substance abuse. I might have some, learning deficiencies and stuff like that. So I'm trying to get to the bottom of it.
I like
so
this
yeah,
guy.
thank you for hearing me out.
I like this guy.
okay. So, and sir, if you were to test today, what would be detected in your system?
Nothing.
Okay. So here's what the court's going to do. The court's going to indicate a $5,000 10% bond. The court's going to indicate upon posting that bond, you are to participate in random testing. So if you post that bond today, sir, do not leave without stopping at probation to get set up with your random testing.
Okay. All right. Thank you, Your Honor.
And then you're not to possess or consume any alcohol or drugs unless prescribed. And you are to continue with with treatment and appointments.
Okay.
What's up, not a brat?
All right.
I must
Anything
say.
else? The court will also note that. All right. The court also noted that the court signed the petition order for court-appointed attorney for felony matters.
This guy was good. I just had to show her court didn't have any crazies today. I just because he was hard of hearing, and I had to put DeSanto after her break. Judge DeSanto, if you're watching this right now, I mean no disrespect when I give you hugs and kisses. You are my girl. You're my type. I love you. Time served. All right, here we go. She makes me all goofy inside. All right, people. We got a couple main events. We got a couple TPOs stuff. We got Mike Page. We got stuff going on. Let me just do one more. I'll do, you know what? Let's get a little Judge Simpson going on. Ooh, this was a goodie. All right, here we go. We'll go Judge Simpson, and then we'll go to our main events. Here we go, Judge Simpson.
Mr. Pharrell, I thoroughly re-explained to him the terms of his bond, and I made it clear to him any confusion that he had. He expressed to me that he didn't fully understand the terms of the no contact, and due to the non-threatening nature of the contact that he made, we would ask for some leniency from the court, perhaps, as well as the fact that his ultimate goal was to figure out what was going on with his child, Your Honor, and that's it. He was not trying to make any physical contact with her. He has maintained his distance. He has not been trying to see her. He simply misunderstood the terms of his contact regarding his child, Your Honor. And like I said, I have thoroughly went over those with him, and now he knows. He clearly understands the terms of his bond and what no contact means.
And Your Honor, if I may respond.
Yes.
While I agree that they're not necessarily threatening, they're definitely harassing. These text messages are coming in at numerous times of the day, including 4:47 a.m. Some of them are at 8 p.m. I believe there's only a few that actually relate to his child directly. There's one in particular that says, you don't have to put me in jail to go be free whenever you want to be done with somebody. Just tell them that. That has nothing to do with their child. The next one says, I would never think about putting you behind bars, and it's been times I could have, but for what? This is actually like bordering witness interference. These are harassing communications. So whether he is saying they were just for his child, or if he knew or not knew, the magistrate does go over the domestic violence terms at every arraignment. He does have an attorney. He was able to ask them if he could contact the victim and or not about their child. And I just have concerns that these texts they're not stopping. So it's not a once, how is our child doing? Is she doing okay in school? There's also a text message that says, you could have told me you not effing with me like that, but I knew I should have listened to mine first when I was gone.
Thursday, baby.
And it continues. There's some profanity in there and slurs. So I mean, this is just inappropriate conversation, especially since his excuse is that it's all about their child, which I don't believe that's true.
Wow. Your Honor, I would also like to make a response to that. There are numerous requests for him to speak to his child. There are numerous apologies, and as well as a text message that says, I'm not trying to feud with anybody anymore. He's repeatedly apologized. Can I at least talk to her more than once? So like I said, the ultimate goal is for him to try to speak with his child and figure out what was going on with his child. And like I said, the text messages include numerous apologies. They're not any type of violent conduct or any type of threats made. So I would just wanted to address that.
Well, not direct, but what is it about these? There's actually audio calls instead of type messages.
I was trying to read. Oh, sorry.
Mr. Pharrell, I'll handle it.
I mean, I've got missed audio calls from him to her.
She's wrong.
April 5th at 3:55 p.m., April 5th at 9:54 p.m., April 6th at 11:44 a.m., April 8th, 9:45 a.m. And then there's another one that doesn't have a date, or it's at least cut off. Then April 8th at 10:07 a.m. I just think when I look at these, I mean, that's a problem. He's not supposed to be having any contact. If there's a child involved, then there's a mechanism by which he can go through to deal with that. And had he contacted you, but these are numerous contacts, sort of over and over.
Thanks, Billy.
There's a missed audio call. He doesn't call, but I mean, doesn't call her back. And he just keeps going. Time and time again. And just doesn't seem to understand not only the court's conditions, but if somebody's not responding, then they're not responding.
I haven't contacted her since.
But while you're ahead,
Well, I just gotta lose Kamaya like this, bro. This is crazy. But you
That's
see
the
what
problem.
you trying to do?
That's what you should do best. Don't just look at you. It's your daughter too.
You can see he's deeply concerned for his daughter, Your Honor, and I understand, and I made it very clear to him going forward what the conditions of no contact means.
Yes, you did. And man, this is frustrating.
Can I talk to him?
I don't know if you can do that. Excuse me, sir. I don't know if I'm even supposed to be talking.
Mr. Pharrell, if you'd like to speak, you just mute yourself.
Oh, can I?
I'll set a bond.
Say nothing.
Is he done?
Yeah, he's done, Your Honor.
I'll set a bond hearing for April 24th, 2023, 9 a.m. Mainly to go through how this can't or shouldn't occur before. But at this time, given what I see here, the defendant's bond is hereby ordered to revoke. Defendant to report to the Washtenaw County Jail by 6 p.m. this evening.
So,
excuse me, sir.
And that hearing on the 24th is in person.
Your Honor, may I say something?
If you'd like, Mr.
I'm not even in the state of Michigan. Like, how would I be able to just report myself to jail like that? That's what I'm trying to get you to understand. Like, I'm not, like, I fully understand the terms of no contact and all that he went over with me, but I'm miles away from there. Like, I'm just been reaching out there because my daughter came to the state of Michigan with me. She was in my possession. And all this happened. You know what I'm saying? I was up there to help her get on her feet. And boom, she called the police out of a misunderstanding. If you look at the body cam on your officers that arrested me,
you might
Mr. Pharrell, Mr. Pharrell, please just refrain from speaking about anything more that happened that day.
What state is he in?
Uh-oh.
I'm in.
Where are you currently?
I'm in Georgia.
And Your Honor, I don't see anything about from the arraignment where he is supposed to be in Georgia. My notes say that he was given PR here, and then he was taken to Wayne County and served 30 days in jail. And the magistrate explained that he had the no contact and no go-to order still in place. And I'm looking in GIS, and I don't see anything about his residence being in Georgia.
That's what my current ID when they arrested me says Georgia. My ID and my property says Georgia.
Sir, Mr. Pharrell. Maybe you didn't understand what the magistrate was telling you, but if you want to keep interrupting me, you can keep interrupting me, but I'm about to tell you something, because part of your bond conditions are you are not to leave the state of Michigan without permission of the court. And when you said you weren't in the state, I'm looking through the file, the actual paper part of the file, to try and determine whether or not anybody granted you permission to leave the state. And I don't see it. I don't see it in terms of any paperwork, and I also don't see it in terms of any. There's no order which allows you to leave the state.
Man.
Well, here's what I'm going to do. I'm going to set he's got violations all over the place. He's got no contact violations. He's left the state without the permission of the court. I'm going to set the bond hearing for the time and date that I said of April 24th, 2023, 9 a.m. That will be in person. I'm going to give the defendant 2 days to report to the Washtenaw County Jail. What's Wednesday?
Wednesday is the 19th.
I'll give him until the 19th, presuming that he doesn't. I don't know how you misunderstand that order. April 19th, or a bench warrant will issue with no bond.
Can Am I allowed to say that? No.
Judge, I'm so sorry. What time? By what time on the 19th?
By 6 p.m. on the 19th.
Thank you,
I'll
Judge.
give him. Okay.
He's the GOAT.
He shouldn't have, and I'm sure counsel explained to him, he shouldn't have left the state. He shouldn't have been contacting her. Shouldn't have been doing a lot of things that are in this. And the magistrate told him there's a signed order to that effect. And then just wants to do it his way. Well, now we'll do it my way.
And then he cuts
Thank
it.
you.
Watch.
What?
And then he cut the feed.
21-58021.
Okay. Brace yourself, people, for this one. Ooh, it is juicy. Here we go. Mike Page never disappoints. Here we go. Oh, and we will be highlighting court. It won by a narrow margin. So I guess what we'll do is we will put court, Karen's, and then the police chases also, and whatever else is going on that day. Here we go.
Samantha Schomber and Randy Boersma. Can you both hear me?
Yes.
Yes, sir.
All right. This is a date and time set for hearing. Mr. Boersma's filed a motion regarding parenting time. Both raise your right hands. Do you both swear or affirm any testimony you give in this cause will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Yes, sir.
All right, sir, why don't you tell me what you're requesting and why?
Well, I'm supposed to, in our divorce agreement, I'm supposed to have phone calls and visitation with my children. I've been blocked since last June from calling them. Her and my mother have issues, and the last letter I've received from her was not very good, but I've been blocked from having any contact with my children. My family's been blocked from having any contact with my children. My grandfather's not doing well. I hope he makes it until I get out of here. None of my family's got to see my kids. I have no communication with them whatsoever. I just want to be able to maintain a relationship with my children. I get out this November. I'm in a really good program right now. I'm taking the welding class. I'll be a certified welder when I leave here. I'm in advanced substance abuse treatment. I've taken Thinking for a Change. I go to NA meetings every week. I'm doing everything I can while in this bad situation I put myself in to try and be a better person and father when I get out. But she won't, I can't contact my children. I mean, I just want to have a relationship with my daughters.
All right. Okay. Ma'am, what's your response?
I have not had a phone since August 12th of last year, a working phone.
What? It's 2023, lady.
You got something now. What are you doing right now?
I'm at my neighbor's while she watches my kids on her laptop.
Oh, you don't have any kind of device right now at all?
No.
You
I have a laptop. I have no charger for it.
What?
You have a laptop without a charger. You have no phone?
I'm a single mother of 4. I have no income. I live with my family, and I don't have the means for it, really.
Why do you say you're a single mother of 4 with no income and we're supposed to feel sorry for you? Get a job. I don't get it. There's jobs everywhere. Mike Page is astounded that this woman does not have a device. And he should be. You're a mother of 4. You should have a device, lady. Makes me sick. This guy's in jail. Listen, he probably messed up, probably was a deadbeat father, whatever, but he's turned his life around, at least from what we see. And this woman is doing, come on, man. 2 sides to every story, but don't give me that 4. I got 4 kids. I live with my family. I got no income. Get a job.
She was able to send me this JPay last September somehow.
All right. Well, she said she's been without a phone since October, so that would be after September.
August. But I haven't been allowed to talk to my kids since last June when she blocked me when she did have a phone. So I don't know what. I haven't spoken to my kids since last June, Your Honor. That was the last time I've had any contact with anything besides this JPay that she sent me in September, which I could read this to you.
Oh boy.
If you'd like.
Well, I don't know if it's relevant, but go ahead, I guess.
Oh, it's relevant.
It's pretty, it says, thanks to your mother, I have no phone for over a month now. So let her know what a good thing she did. Don't know when I'll get it back from the police, so don't count on hearing from my kids anytime soon. I refuse to put any more money into you or your relationship with your children. You are all completely nuts and are trash who don't take care of family. Oh, your mom just got arrested again. Funny, since she tried getting me and my fiance in trouble, claiming we are drug addicts. For one, neither of you have met my fiance and or other than the CPS cases with you, I have claiming no drug history or using drugs. I guess the police realized that when your mother fed them false information and they surrounded my dad's house with guns and then found out we had moved out over 2 weeks earlier. Smart, so much humor. Why don't you and your low-life mother leave me and mine alone? We're doing just fine without your drama and bullshit. This was the very last straw. I will never deal with you or anyone in your family again for my own sanity and the benefit of my children. You people don't have the first clue about my kids. Keep making me out to be such an awful person, and we will never co-parent successfully. Learn your motherfucking place. The same as Zachary. Y'all ain't shit and will never be what I am to my kids. They know the deal with you both. I used to, but I would never let that get in the way of being a mother to my kids. Point blank, period. Never let it take me away from my kids, even for a single night. Never. So guess I'll see you in court in a year. Again, be sure to thank your mother for not being able to get a hold of you, my kids. Really did me a favor. LOL. That's the last communication I've had.
Okay.
I mean, she obviously could send that JPay, so I can't get a picture of my children. I can't. My family will get the kids a phone, but my family is also they're not allowed to see my children. She won't deal with my dad. None of them.
Well, she's under no obligation to. Your dad does not have parenting time or custody rights.
No, but they will. My parents are willing to help her out with the kids. They're willing to help. They're willing to help buy school clothes. They're willing to do whatever. They're willing to help her out.
Scummy mummy.
So, let's see.
And I don't.
So
wait, is Mike Page speechless? Did this couple actually make him speechless? He doesn't know what to do right now.
Man,
he's scratching with a pen. Poor Mike Page. He's stumped.
Her dad gives her a cell phone on his phone plan. So, I mean, her number's active. It's blocked when I call it.
It's not blocked.
How can it not? Ma'am, if you don't have a phone, what do you mean it's not blocked? You said you didn't have a phone.
It's not. He said this. It was blocked since he was in Nuevo County Jail here, and it was never. I have my 652 number is on a plan. My dad does pay for it. I don't have that phone. That's the phone the police took, and I don't have it.
What the police?
You should have been able to get the police took her phone because she stole my mom's email accounts. My mom had to send the police to get her email records back. Like, my mom has the police report. She stole my mother's email information. The cops went and raided her house and took the phone.
I never got charged
with
anything.
So I have the police report that's saying she has several of my email accounts, all my Facebook accounts, and my mother's
I
email.
don't have the phone.
She should have been able to get that phone back. The charges were never filed. There's no reason she shouldn't have that phone back.
All right, I swear you both in. So, ma'am, is it your sworn testimony right now that you don't have a phone or access to any device upon which your children?
He made her swear. He reminded her that she was under, that she swore that she doesn't have a device. He still can't get over she doesn't have a device.
Children could contact their father?
Why does she look like a Muppet?
Yes. Not a regular device. No, not like consistent access to.
All right, but he said something about your. Hold on.
She's a troll, real life troll.
Sir, or ma'am, he said something about your parents providing you with a phone or a plan.
A phone plan, yes.
Okay.
The phone is on there, but the phone is broken. I don't have it. I don't have it.
Do your parents live close to you?
I live with my father, yes.
Oh, does he have a phone?
Yes.
Oh, well, why can't you just use that one?
if he wants to call it, I mean, that's fine. That could work. Him and my father are not decent at all.
Well, I don't care. They don't
I
need.
mean, I
they
could.
don't-
I
they don't
can give
need
you
to
the
talk.
number right now. I was even going to bring up, I don't feel like I should have to pay for his video visits that he's asking, but I will make it so I can use this computer on a certain day, certain time every week, once a week, as like a visitation normally would be out here.
What?
So he can speak to the kids. I would be fine with that.
All right, how old are the kids?
3 and 5, about to be 4 and 5.
All right, so is one of them in school then, or
No, they both start this fall.
so they're both home all day?
Yes.
All right. Sir, what time?
Can I add though, I do have 2 other older kids that do view him as their father still. So if it is possible, it is summer soon. So if it is possible right now to make it after 4, they get off the bus at 4.
Oh, do they want to see him too?
Yes.
All right. Sir, what day are you available after 4 o'clock?
I go to school 5 days a week here. I'm in the welding trade program.
Thanks.
And I have ASAT classes at night. I go to advanced substance abuse treatment 3 nights a week, but the weekends I am available.
Thanks, James.
Like I say, my family will give her money for the visits. I mean, I can't personally pay for the visits.
You've got access to this computer. What time? What day?
It costs $3.20 for a video visit. So my family will give her the money for that. My family will also give the kids a phone. So, if she can get a hold of my dad will provide all that for her.
Oh. Just use
And
Zoom.
I like to thank her
Zoom.
for
It's
allowing
free,
me to
isn't it?
talk to the other kids.
Just use Zoom like this. One of you create an account, and Zoom is free. You get 40 minutes for free. I don't know why you would pay for anything.
I did not know that. I was told here that it's a $3.20 it's $3.20 for a 20-minute meeting for visitation here. Unless you guys are willing to set it up, I don't know how that works. But for a regular visitation,
the state will do it.
It's $3.20 for the visits here for a 20-minute video visit.
All right. Well, I don't know if I'm able to do anything about a prison charge. Probably not. I mean, I'm just saying if it's $3.20, if the $3.20 is for some video chat service, Zoom is free. I think Skype is free. There are a bunch of free ones if that's what you're paying for.
Yeah, I'm not sure how that works. I just know that I have people here that get video visits with their family, and it costs $3.20 for a 20-minute video visit.
All right. Well, I don't know. What day works? Is there a weekday that works after 4?
Saturday or Sunday is fine for me.
Saturday or Sunday? All right. So Saturday or Sunday wouldn't have to be after 4, right, ma'am?
Can we do like a Sunday evening?
Sunday at 6?
Saturday evening?
Okay.
Sunday at 6.
That'd be fine.
Audio or video chat, depending on what you can make work.
And if there's any way I get a free phone call every week. I'm willing to pay for phone calls. I don't personally have any issues with her dad. I have nothing but, her dad's a great guy. I have no issues or problems with him. Whatever his are with me, I don't know, but I just want to have I just want to be able I haven't talked to my kids since June of last year, and I'd really like to be able to talk to my daughters.
All right. Well, I'm not going to obligate her dad to anything. I don't have jurisdiction over him if it's his phone. If you call it and he picks up and says, yeah, here you go, talk to the kids, I don't have a problem with that. But I'm not going to say that he has to, but you'll have a audio or video chat Sundays at 6 via whatever service you guys can make work.
And then because it does cost, because it's through the prison, he has to do it through there where it costs the $3. So am I ordered to pay that or?
No, his parents can send him money if they need money, or his friends or somebody.
I just need to know how they can send that money to it.
I don't know, just put it in your commissary account, don't they?
She could sell some extra EL fudges.
I can't do anything out of my account to pay for the visits here. I can't. I cannot set that up through here. It's not on me. Not that I don't want to. I physically can't do it from here. She has to do it from out there.
Or his parents can do it and then let me know
How did they
somehow.
let her know she don't have a phone?
I do have access on this computer. I mean, I can check my Facebook here and there because I do have his stepmom.
I talked to my stepmom and she says she's been blocked from any contact with her.
I think she has a cleft palate. That's what I think it is. I think it's a cleft palate. Which, I don't care if it's a cleft palate or not. Her looks have nothing to do with that she's a deadbeat. She could be the prettiest woman in the world and she could still be a jerk. And what she is, so.
She's been sending me messages. She's not blocked. I just don't respond because it's not relevant. But now that it is, I will respond to her enough to get the visits for the kids, and then that's all we need.
Well, if you can, send me a JPay so I can send. I don't have my dad or anything on JPay. I can call him tonight, but I can send her the information through. I have my stepdaughter on JPay.
Mike Page is done.
It costs 25 cents to send a JPay. I can send her the information to set up the video. I can have my parents send her the money through Facebook or whatever.
Possibly inbred.
My dad has no problem. I can call my dad tonight and have him set all that up.
Tino.
All right. That's all fine. I guess, ma'am, if you incur any out-of-pocket costs, just keep track of it. And then when he's out, an order could be entered for reimbursement if that's what it comes to.
Yeah, I have no problem paying
I'll
for
sign
it.
that.
Okay. Sounds good. So the order I'm going to do will say Sundays at 6 for an audio or video chat. Okay.
Oh boy, that was a doozy. Here we go. We got another one. I told you I had some good ones. I always serve up the best clips. You guys are always getting served. Let's go. Let's go to Judge Kirkman. Here we go. What up, cleavage?
This is case 2023-432 PP. Brittany Adams versus Lewis Adams. Attorney Kimberly Wickham represents defendant. He is attending via.
She's another one. Why I call this Maniac Monday, because she is a maniac.
Telephone.
Okay. Court will note this matter is before the court on the defendant's motion to terminate the personal protective order. What we're going to do is potentially take testimony from both of the parties. So I'll have Ms. Adams, Mr. Adams, have you raise your right hand, be sworn in, and then we'll proceed.
All right. Do you solemnly swear or affirm that testimony you're about to give shall be the whole truth and nothing but the truth?
Yes, sir.
I swear. Okay. Ms. Wickham, you can proceed.
Thank you, Your Honor. I'd like to start with my client, Lewis Adams, please.
Okay.
Thank you. Mr. Adams, will you please state your full name and spell your last name for the record?
Lewis Robert Adams, A-D-A-M-S.
Thank you. And Mr. Adams, you are the respondent in this case, and you filed this motion to terminate the personal protection order. Is that correct?
Yes.
Let me start first by asking you, how did you find out that there was this personal protection order against you with your wife, Brittany Adams?
If you hear background stuff, that's the court, not me. I have all the mics off when I was recording. I wasn't even near the computer, so I don't know what that was. That's the court.
I found out.
Hear it?
I got a letter in the mail saying to surrender my CTO.
Okay. And did that prompt you to go to the circuit court clerk's office to ask about any personal protection order against you?
Yes.
Do you recall the date that you were served with the personal protection order?
The date? No, I was served the day before our custody hearing.
Okay, so would that be the business day before?
Yes.
Okay, and you had a motion hearing in your custody or divorce matter on March 13th, is that correct?
Yes.
So do you believe that you were served with this PPO on March 10th then? That would have been that Friday before?
Yes.
And who served you with that PPO?
Brittany Adams' friend, Taylor Van Sweden.
Okay, and is it your understanding that this PPO was issued on February 14th?
Yes.
Between February 14th and March 10th, did you continue to have contact with Ms. Adams?
Yes.
And was that for child-related matters?
Yes.
Did she at any point tell you that there was a personal protection order that she had requested of the court?
No.
At all times, was that contact peaceable?
Yes.
There was absolutely zero assaultive or threatening behavior towards her?
No, there wasn't.
Does Ms. Adams know where you live?
Yes.
Is that in fact in the marital home?
Yes.
And is she also aware of where you work and what your work schedule is?
She looks
nuts.
Did she at any point attempt to serve you previous to being served on March 10th?
No.
Okay. And again, you were made aware because you were requested to surrender your CPL, is that correct?
Yes.
All right. Sir, turning to the verified statement that Ms. Adams had attached to her request for a personal protection order, she lists 5 separate incidents, and I'm going to go through them with you. You responded to a few of them, but let's start with the January of 2022 incident. Do you recall the statements she made in her verified statement?
Yes.
And do you recall the answer that you filed?
Yes.
Do you have anything to supplement the court with regards to the answer to that incident?
No.
Okay. If she stated that you had come into her room mad at her, is that in fact false?
Yes, ma'am.
And she had in fact been out drinking the entire night before?
I can't tell you she was drinking the entire night, but when she got home from her party, I could tell that she had been drinking or under the influence of something.
Okay. And you in fact stated that you smelled alcohol on her breath?
I did.
And you said you also inspected her pupils because she had previously had a substance use issue and you were able to tell if she was under the influence by looking at her pupils?
Yes.
And that's something that you were able to do over the number of years that she had her substance use during your marriage?
Yes, I began to learn about her mannerisms when she was under the influence.
Okay.
What's up, Amy?
So in fact, you don't believe she was in any position to be able to recall any incident that happened January 2022, the date to which she's referring?
No, I don't.
Okay. Was she in fact driving your father's vehicle?
Yes.
And she in fact, due to her absence from the home, caused you to have to call into work?
Yes.
Okay. With regards to the incident that she's referring to as the spring of 2020 incident, do you recall what she put in her verified statement?
I'm looking at it, yeah.
Okay. With regards to that incident, were you in her face yelling at her or poking her in her chest?
I was upset. My voice was raised, but I wasn't poking her. No.
Did you, in fact, grab her arm and throw her on the bed?
No, we weren't even in the bed. We never made it to the bedroom. That's a lie.
Okay. Do you recall the incidents that led up to that particular instance she is referring to?
Yes.
And what was going on right before she says all of these things happened?
As far as, okay, so the day before, I got home from work and she was, getting ready, and I asked her, are we going somewhere or whatever? I don't remember the exact words, but I aired to, what's going on. And she said her girlfriends called her and said there was I believe it was a birthday party. And she was going, and she'd be home, you know, between 11 and 12 o'clock or whatever. I had worked, I believe I worked a 12-hour shift that day.
Okay,
So,
and we're
you know,
Mr. Adams, I want to make sure we're talking about the correct incident. This happened, she's saying something happened in the spring of 2020. The very next incident that she's referring to, not the January of 2022, the spring of 2020.
oh, spring, okay.
Yep,
Okay, hold on, I'm sorry.
that's okay. Regarding that particular incident, do you know what was going on between you two prior to what she says happened?
No, like, none of this makes any sense.
Okay, so Mr.
No,
Adams.
I don't.
Okay, you don't remember? All right. So you've had a chance to read those allegations. You indicated that you were yelling at her, but at no point did you put your hands on her?
No.
Okay. Did you at all threaten her life and say you wish she was dead?
No.
Okay. Flipping then, sir, to the August of 2019 incident, that would be on the second page of her verified statement. Do you have that in front of you?
Okay. Yes, I do. Sorry.
Thank you. That's okay. So, Mr. Adams, have you had an opportunity to read those allegations?
Yes.
Did you, in fact, charge her up against a wall and choke her?
No.
Okay. Did you, in fact, hold her down and call her all of those names she's saying that you called her?
I don't recall. We were yelling at each other. I don't recall calling her all this stuff. I was angry though.
Did you start breaking things and throwing her phone at her head?
No.
Did you put any holes in the walls?
No.
Okay. Regarding the November 2018 incident, are you with me on that page on the verified statement, page 2?
Yeah. Yes.
Have you had a chance to read that allegation?
Yes.
Did you, in fact, show up to where she was staying?
Tell the truth.
Where she was staying.
Yep, she alleges that you showed up to where it says we were staying and Lewis was in our room talking bad about me, calling me worthless.
I do recall this.
Okay, you recall this incident? Do you recall saying that?
I may have said that, but there's a whole lot of things that are not in the statement.
Okay. Did you kick her from behind?
No.
Did you at all physically assault her during that incident?
No.
What were you guys having an argument about where you may have called her worthless?
I had found out from her friend Harley had told me that she was cheating on me with James Guy, and I had found out about it and spoke with him, and he admitted it.
She's a hoe.
So I was, it's just another time she found a reason to sleep with somebody else behind my back.
Wow.
So you were in fact upset that she was not being true to your marital vows?
Yes.
Okay, but at no time did you physically assault her or threaten her life because of that?
No, I don't know why she would not have called the police if I did all that.
Okay. She indicates that the police were contacted. Did you have any police contact on that day?
I don't remember.
Okay.
2018.
Okay. All right. So suffice to say, you just don't remember?
No.
Okay. Regarding the August of 2010 incident, have you had an opportunity to review the allegation that she has written in her verified statement?
Yes.
On this particular incident, do you recall what she's referring to?
Yes.
Were you in fact drinking on that day?
Yes.
Did you, in fact, chase her into the apartment and start punching her in her stomach and sides?
No.
Did you punch her in her arms?
No.
Did you choke her and say that you were going to kill her and the baby?
No.
I didn't hear this part.
Did you, in fact, have any sort of police contact on that day?
Yes.
What was the result of that police contact?
I really don't remember.
Okay.
I don't remember.
Okay. Do you have any sort of criminal charges, I'm sorry, or do you have a conviction for that incident?
No.
Okay. Regarding all of these incidents, she's listing the most recent one as January of 2022. Is that correct?
Yes.
Okay. When, sir, did you in fact file for divorce?
January something.
Of this year?
Ooh,
No,
she's getting
December.
antsy.
It was December of last year.
Okay. And have you, since separating from Miss Adams, had any sort of assaultive behavior?
Agreed. Muse.
No, absolutely not.
Has she been assaultive towards you?
No. Since the divorce?
Correct.
Or no.
And have you guys been able to have child exchanges for parenting time without incident?
Yes.
When did Miss Adams leave the marital home, if you remember?
I don't remember the day. All I remember is that you gotta understand this is all very stressful. So, but I know I came home from working the double shift and my house was trashed and empty. Everyone was gone.
Okay. Mr. Adams, is there anything else that you would like the court to be aware of with regards to your request to terminate the personal protection order?
Bill Rhodes, idiot.
As far as all the time she's assaulted me, or
well,
I guess I don't understand what you're asking me.
Yep. So Mr. Adams, let me ask you this. We've talked a lot about Miss Adams accusing you of physically assaulting her. Has Miss Adams throughout your marriage been physically assaultive towards you?
Yes.
I know it may be hard to recall the number of incidents or that you may not have kept track of them. But when you think about your marriage and the physical assaults by Miss Adams, how would you characterize the number of them?
More than 5, less than 10, somewhere in there.
All right. And did in fact, throughout your marriage, you guys have a lot of strife because of her actions?
Nice word. Strife.
Yes.
And did they have to do a lot with her substance use, that being drugs or alcohol, and her fidelity?
Yes.
He's a drug-toting hoe.
Thank you, Your Honor. I have no further questions.
Okay. Ms. Adams, do you have any questions of Mr. Adams?
Here we go.
Wait.
You're muted, ma'am. You have to unmute.
No, sir, I have no questions.
What?
Okay. That's fine. Ms. Adams, what would you like to tell me?
I would like to say that first of all, the allegations I had written down and put in the paperwork for my verified statement are all 100% true. I have an audio recording of the incident as of January. I have an hour-long audio, which I showed to the police officer, which is why he was arrested that day. where he clearly says, "I will kill you," in the audio. As for the second incident in November, or sorry, wrong page.
Get a loose leaf.
In spring, sorry, there was no police contact on that one. And as for the last one, he did go to jail when he hit me when I was pregnant. He was arrested and his mother bailed him out. The reason there was never any charges pressed is because he threatened me that if I followed through on the charges, that I would pay for it. I also have multiple police reports and I have multiple witnesses along with, and I don't want to ever have to do this, but my children have witnessed him put his hands on me more than 5 times.
Oh, so bad.
Okay.
I would never lay my hands on a woman. Oh, ever.
I'm doing this for the safety of myself, and he's concerned with his guns. He called me the day he got that letter and said, "I can't believe you got a PPO on me, and now I have to get rid of my guns."
Anything else you'd like me to be aware of, ma'am?
No, sir.
Okay. Ms. Wickham, any questions for petition?
Pew pews.
I have no questions for her. Thank you.
Okay. Okay, I guess any, Ms. Wickham, any additional witnesses?
I have no additional witnesses. I would be comfortable now moving to closing arguments.
We'll be doing something soon together.
Okay. Ms. Adams, do you have any witnesses?
Not at this time, no.
Okay. Okay, Ms. Wickham, any closing argument?
Yes, thank you, Your Honor. With this motion to terminate the personal protection order, my client has testified that these incidents are taken out of proportion, added additional convenient details. And what I would like Your Honor to note is the similarity or the timing with which this PPO was filed and served. Your Honor is aware of the divorce case between the parties that is in docket 2022-3374-DM. The divorce was served on Miss Adams on January 5th. The answer was filed by her counsel on January 24th. Our office, through Ms. Podolsky, did file a motion for temporary custody. We signed that on February 7th. The defendant's answer, that being Miss Adams in that matter, her answer to the motion was signed on February 14th. If Your Honor takes a look at the verified statement, February 14th is the date that is on the verified statement. The timing with which the answer and the contents of the answer in the divorce case to that motion, alleging that our client is physically abusive with the request for the personal protection order, as well as the timing of the PPO being served. The fact that the PPO was in existence for almost an entire month. If Miss Adams felt the need to have an ex parte motion request for a personal protection order, that she was so clearly afraid for her physical safety, for her life, for fear of being harmed from our client, she certainly would not have waited almost an entire month and then served him the last business day, if you will, before the motion hearing on Mr. Adams' motion for temporary custody support and parenting time, which occurred on March 13th. He was served on March 10th. They continued to have contact throughout that time. She does not list any incident any newer than January of 2022. If Miss Adams had any sort of evidence or witnesses, today was the date and time that she needed to bring that. We had given her plenty of time and notice with regards to the hearing being today. So, Your Honor, she had a sufficient number of days with which she could have prepared, brought the evidence that is necessary and any witnesses. I would ask Your Honor to consider heavily the timing with which the request for the PPO, her answer in the divorce case, the hopes that it would bolster your decision with regards to the custody support and parenting time issue before you in the divorce matter, and as well as the significant delay in an ex parte order for a PPO, which Your Honor is well aware of is to protect her. If she had that genuine concern and fear, knowing where he lives, the marital home, knowing his work schedule and where he is, she had her friend serve him on March 10th when she had an order since March 14th. Thank you, Your Honor.
Okay, thank you. Ms. Adams, would you like to make any statement at this point, argument?
I would just like to say, if I didn't know I needed to have all my proof today, or I would have most definitely had it. The reason it took so long to get him served is because the 3 times I had someone go to his work, they made a joke out of it and would not call him down to the front desk where he works. You cannot just go in there. You have to go to the front office. It is a big building. You can't just go in there and see whoever you want. The 3 people that I had tried to go to his house, I should have done it a different way. I wasn't sure. I've never had to have a PPO before. They were scared and decided as they went to his house, they didn't want to do it. I finally found someone to do it, and it was my best friend, yes, and it was because she was afraid for me, so she went and did it for me because it needed to be done. I had tried on multiple occasions to have him served, and it just didn't happen. As for the evidence, I did not know I should have had all of that here today with me, but I do have every bit of that evidence, including the entire hour-long audio of him threatening to kill me.
Okay. Anything else, ma'am?
I'm not going to disagree that we've been communicable with the kids and the transport of the kids. We've been trying to keep our nonsense away from them as we should. So we both have always made it pretty easy when we have to be around the kids. I think that's it. I'm sorry.
Okay. Anything else, Ms. Wickham?
What I'll say, Your Honor, is that if she had such difficulty serving him, it's my understanding that she could have had a sheriff's officer, deputy, serve him. I believe that the PPO coordinator generally requests whether or not they need assistance serving. So I'm not sure I put much stock into the fact that she had difficulty serving him. I do believe that it was a calculated process of service and that she had ample opportunity to do it.
Okay, thank you. Well, in this matter, the court's again looked at all the pleadings, also has heard the testimony today. Somewhat, again, I guess you'd say difficult because we have Ms. Adams is not represented. She had a right to be so. She just chose not to. And again, as a result, she has not presented any witnesses other than her own brief testimony. The court would note that this PPO was entered on February 14, 2023. The most recent event that she alleges occurred was on January of 2022, more than a year prior to this issuance of the personal protective order. The court does have the ability to and can enjoin or restrain certain conduct if the court determines there's reasonable cause to believe that an individual has committed or commit any of the acts listed under MCL 600.2950 parens 1A through K in this particular matter. There is allegations of those, but the court would note, again, the most recent was in January of 2022. The plaintiff or petitioner alleges that, again, some of these instances occurred where there was some physical assault. The defendant respondent denies that there was any physical assault in this matter. It has, the court would note, since the entry of this in February of 2023, the parties have had regular communication. They've exchanged child or children in this matter without incident. The court does note that the PPO entered in this matter simply restrained and enjoined the respondent from entering upon the property where she lives or assaulting her or threatening to assault or injure her in this case. The court does note, however, that, again, the court is troubled by the fact that the most recent events were more than 14 months prior to the filing of the petition. and that petition was filed immediately preceding the filing of the divorce action, which is suspect in this particular case.
Called her out.
As a result, in this matter, the court does not believe and does not have reasonable cause to believe that the individual committed or may commit those events. The court is going to grant the petition to terminate the personal protective order at this
Gets
time.
his guns back.
I will inform you, ma'am, in this matter, that doesn't mean that should the respondent take action in the future, you always have a right to file a additional petition in this matter, alleging whatever has occurred in this particular case since that date. But the court does believe that parties have been getting along amiably in this matter. And as a result, the court is going to terminate the personal protective order. With that, the court will conclude this matter at 11:30 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
See you later, boobies.
Okay.
Okay, we got one from Washington that I was holding for you. This is a good one too. Let's watch Miss Ware in the
We'll
bottom.
call the case of Ypsilanti Township versus Teresa Ware, 23T00285, as well as 22T00694.
Paul Barnett on behalf of the township.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Miss Teresa Ware.
Hi. Please state your name, ma'am.
Teresa Ware.
Good morning.
Good morning.
We're here for pretrial in 22T00694 and 285.
Okay, so this bench warrant was recalled. Judge, we have not. Did you say one moment, Your Honor?
Can I say something, please?
No, I did not
Can I
say one.
something?
And not yet, Ms. Ware.
Okay.
Judge, we're asking for an adjournment in this matter. I think we just received notice that Ms. Ware was just recently released from the hospital. We hadn't been able to contact her after we got the bench warrant.
Hey man, I gotta tell you, I was in jail too.
Okay.
But and I was supposed to be in court that day, and the police came, the Ipsy police and the Washington police came, said I had a nationwide on your side, didn't do nothing wrong.
She just said, I have a nationwide on my side.
I was at home holding my baby. Police and the Washington police came, said I had a nationwide on your side, didn't do nothing wrong. I was at home holding my baby, grandbaby, and they came and the Ipsy police came and put me in jail. I was in jail and they released me, and I had took care of that because I had my granddaughter, a case on her, and they didn't read me my rights. And I went to jail for trying to help her because she wanted to dance. She's 18 years old. She don't even want her baby. I take care of her, my great-grandbaby.
Ma'am,
Yes,
you're in jail because you failed to appear at a pretrial on March 30th.
I was in the hospital.
I got
And I
knew I
notified
had
the
to go
court
to
of that.
court, and they put me in the hospital because I was trying to get my check, and they did me wrong. I hadn't had no money in 2 months, and they did some stuff to me, but that's okay. I'm gonna leave that alone. I'm gonna let God take care of that. I have nothing to do with what they do to me. I'm gonna leave that alone. But I work for nothing. I get up at 4 in the morning.
Miss
Yes,
Ware,
ma'am.
Miss Ware, this is not the opportunity for you to just go on a rant, ma'am.
Yes.
George Washington.
All right. So, Your Honor, it looks like she is in the courtroom, so we'll just be asking for a brief adjournment. I'll ask her to stick around and at least come in and speak with us so that we can know how she'd like to proceed on this matter.
Yes, ma'am. I didn't do anything wrong.
Okay, Ms. Ware, just give us a
My daddy
second.
was a police officer.
Ms.
for
Ware.
25 years.
Miss Ware, seriously, if you do that again, I'm gonna hold you in contempt. Stop it.
Yes, ma'am. I'm sorry.
Name dropping. This was great. Nationwide is on your side.
Pretrial in this matter is adjourned to May 15th, 2023 at 9 a.m. Bond is continued. Ms. Ware, you need to go. Are you coming out to get her, sending someone out to get her?
Yes, Your Honor.
Ms. Ware, if you could please stay right there so that they can come get you. We're going to give you a notice too, but they're going to come get you so they can talk to you and you can explain all of your issues to them at that time.
Who's
okay?
picking her up? Nationwide?
Thank you, and God bless you, and have a good day.
Thank you, ma'am.
All right.
Bye-bye.
Thank you very much. Have a good day.
But I ain't gonna talk about that. I'm gonna let God sort it out. They got Nationwide on their side of my plate. He was a police officer for 35 years. Judge Washington, she earned her salary today, boy. All right, here we go. Oh, baby, do we got a main event for you? I mean, they were all good today. I couldn't even choose a main event. So this one is just funny because the woman's reactions are just great. We're going to go back to the well. Mr. Mike Page. Here we go. Christopher Sill, thank you for the super chat, super sticker. Thank you, sir. Here we go. Let's do it.
Is you also, right?
Yes, it is me.
Oh,
okay.
Boy. Here we go.
Can you hear
It was working. I'm sorry?
Can you hear us okay?
Oh, this was
Yes,
Kirkman.
I can hear you.
I'm sorry. This is Kirkman.
Okay. Attorney Reed, can you hear us okay?
I'm not patient.
Yes.
Stand
Okay.
corrected. Sorry, guys.
This is case 2023-718 TP, William Blankenship versus Emily Blankenship. It is Monday, April 17th, 2023 at 11:31 a.m. Attorney Jennifer Reed represents petitioner plaintiff.
Ms. Reed, just to check in this matter, court does note that in this matter, your client was not served in sufficient time for this hearing, but it's my understanding that you wish to proceed notwithstanding that. Is that correct, and waive the time frame?
That is correct.
Okay. With that, what I'll do is I'll have Mr. Blankenship and Miss Blankenship, I'll both have you raise your right hands, be sworn in, and then we will take some testimony.
Okay. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes, I do. Yes.
Okay. Ms. Blankenship, this is your petition, so I'll have you give any testimony first in this matter. So, ma'am, you can testify as to what you would like me to be aware of.
The stuff that is worded in this PPO is lies. I am not violent towards him. It's just I want a motion to cancel this against me because there's no reason for this to be happening or to waste your guys' time at this point. I have not been violent with him. I have not threatened him. I am not a violent person.
Okay.
I just want my belongings and to get it over with. That's it.
Ma'am, is there another case proceeding in this particular matter?
Not that I'm aware of.
Okay. Well, if there is, or you can file if your thought is I'm seeking again to acquire property from him, you can file another action and then you can get a order which would grant you access to pick up that property. You understand?
Okay, I did not know how to go about any of this, so I did hire a lawyer to help me with it because I was told that I couldn't do anything with my belongings until I did this meeting today.
Okay.
So that's why I'm here today, so I can try to do something to resolve the problem. I do have a voicemail that Bill wanted me to let him know a time so I could have him and my son Timothy hook up the truck and trailer to bring me my things or to pick them up.
Okay.
So if I'm that violent or, to him, why is he calling me and giving me permission to come and get my things?
Okay. Anything else that you'd like to tell me, ma'am?
It's just lies. I've never harmed him in any way. I've been with.
And the lawyer I thought was a man. That's a woman. Someone asked in the chat. I think. Yeah, because it's Jennifer Reed.
In 27 years and never. But he also has a Ford Lexus in my name. I need to know if I can get possession of it so I can either make the payments or figure out how I'm going to pay for this car.
Okay.
But other than that, no, I just want my things.
Okay. Ms. Reed, do you have any questions of the respondent?
I do. Ms. Blankenship, in your motion, you stated that you did not have any contact with Bill until 3/17/23. Is that correct?
See you later, Madison.
I want to say that was correct. I might be off on the date just because it's kind of a mess with all the dates right now. I know approximately from the 13th through is when all this started, and I just can't remember exact dates of when we actually last communicated. And I do know we were kind of a sister.
You did have police contact at the address of 29 West Bidwell Street in Battle Creek on the 15th of March. Is that correct?
Correct.
And so you were at Bill's house on that date?
I was at our house on that date.
Okay, and the police arrived?
Yes, they did.
And did they inform you that there was a civil dispute between you and they offered you options?
They told me that I could leave. All I wanted to do was leave. I came into my home to get warm because I'd already done slept in my car because he threw me out of the house. So I was in there. When he come home at 5 in the morning, he tried to talk to me, and I said I was tired, I was cold, I didn't want to deal with it. And I went to leave. That's when he demanded the deed to our home and would not let me in my car.
Okay, I have no further questions.
That's when the cops were called.
Okay.
I'm sorry?
Okay. Anything else, ma'am, that you would like to inform me of?
No.
Okay. Ms. Reed, well, I guess Ms. Blankenship, do you have any other witnesses?
Not with me. I didn't know I needed witnesses. That's why I contacted the lawyer. I just haven't talked to him today yet. I don't even know what I'm doing right now.
Okay. Ms. Reed, do you have any witnesses?
I'd like to call Mr. Blankenship, but for the court's information, a divorce between the parties had been filed in case number 2023-867-DM, and I do believe those pleadings are out for service.
Okay, go ahead.
Mr. Blankenship, do you recall filing a petition for a protective order?
Yes, I do.
And when was the first incident?
I want to say it was at my house on the 15th.
Okay, and is that referenced in your petition?
Yes.
And what day is it listed in your petition as?
Is the 17th.
Okay, and you got those dates mixed up?
Yes.
What happened on the 15th?
I tried to stop her from leaving. She bumped me with her car, threatened to kill me, and tore off.
Did she physically touch you that day?
She pushed me to get into her car, to get out of her way. She pushed me to get into her car. And then I stood by her car because there was a car in front of her. She couldn't get out. That's when she backed into me and left.
Okay, and how many, was it once that she threatened to kill you, or was it multiple times?
It's been more than once.
On that specific day?
Agreed.
No, on that day, I think it was just the one time.
Okay. And was there any other incidences?
Just anytime. There was one time she was like hiding in a parking lot up the street at next to Dollar General, and I went up there and she screamed at me, told me to get out of her face or she'd kill me then.
And when was that?
That was a couple weeks before this all started.
Okay. Has she told you that anyone else is going to be hurting you?
And she said she had, in her words, was she had somebody that would do. She had somebody to take care of.
And when did she say that?
That was the last phone conversation we had. I can't remember the exact date.
Okay. And have you had any contact with her since the PPO was issued?
No, ma'am.
Okay. And she had stated that you were leaving her messages or were trying to coordinate a time for her to pick up her belongings. Is that true?
Not with her, only through her children.
Okay. And are you still afraid for your safety?
Yeah, as a matter of fact, past 2 weekends in a row, I've had people pounding on my walls and windows of my house. Last weekend, I called the police twice. This just happened again Saturday morning at 4:00 a.m. I didn't call him this time. The oldest boy was there and he went out, but it didn't happen again since.
Okay, but you don't have any information in that it's Mrs. Blankenship doing that?
No.
Has this pounding, knocking occurred before?
No.
Okay. Are you requesting that this PPO remain in place?
Yeah.
And why?
Because she's unstable. I don't trust her. I mean, I'm scared of her.
Okay. Is there anything else you'd like the court to know?
I believe him.
No, but she has put her hands on me before. My kids have seen it.
Okay. And is that recently?
No, that's been a while. That's a couple years, few years.
Okay, I have no further questions.
Okay. Okay, Ms. Blankenship, do you have any questions of the petitioner?
I do. He says that he had no contact with me, but my voicemails here on 3/17/23, that's when he also called me and asked me if I could let him know a time to pick up my belongings.
Okay, ma'am, this is your time to ask a question, not to give a narrative.
Okay, sorry. I don't.
Okay.
I have no questions.
Okay. Any other witnesses, Ms. Reed?
No, Your Honor.
Okay. Closing argument, Ms. Reed?
Your Honor, my client wishes that this PPO would remain in place. He is fearful of the respondent. She has threatened to kill him on multiple occasions. She's been physically assaultive to him on multiple occasions. She even backed her car into him. So we believe that this PPO is necessary and appropriate, and we're requesting that the respondent's petition or motion be denied.
Okay, thank you. Ms. Blankenship, any closing argument?
No.
Okay. Well, in this matter, the court has heard the testimony as well as reviewed the pleadings in this case, meaning the petition and the respondent's motion in this particular case. The testimony today is that, again, there had been multiple times, as alleged in the petition and the supporting documents, that there had been threats made by the respondent that she would in fact kill the petitioner and or have someone else take care of that. The court does note that the court can grant a personal protective order to enjoin or restrain certain conduct if the court determines there's reasonable cause to believe that the individual has committed or may commit any of the acts listed under MCL 600.2950, parens 1A through K. And obviously, some of those various conditions are assaulting, attacking, bleeding, or beating, molesting, wounding, or threatening to do so. In this particular case, the court has noted that, again, that this personal protective order was entered by Judge Yost Johnson on March 20, 2023, effective for 1 year through the same date on 2024. The court does believe that, based upon the testimony, that there's reasonable cause to believe that the respondent has or may commit some of those particular acts listed under the statute. As a result, the court is going to deny the motion to terminate at this particular time. Let you know, Ms. Blankenship, that the relief you're requesting as it relates to property, that you can have your attorney contact Miss Reed. You can arrange a time when a third party can pick that up, or we can do it as a result of an order in the divorce proceedings and accomplish that. So you do have a way to accomplish what you want and not have any contact with the petitioner. So that will be the order of the court, and we'll conclude this matter at 11:44 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
All right, so I just want to let you guys know that in Judge Goggins, I have a real important message for you guys from Judge Goggins, that, you know, we all kind of sit around and watch court, and we could, you know, get a little, you know, overweight or, you know, lazy. You got to get the blood flowing every once in a while. So in Judge Goggins' court, he adapted something new. It's very serious. So I just wanted you to check this clip out and just, you know, see what they do in Judge Goggins' court now.
April 3rd, he had pled guilty on a felony, and he had another one pending. At this point, he's pled guilty to both those felonies. On April 3rd, he had credit.
And this attorney has a million backgrounds to choose from. Why does he have a scrapyard? Look at Jack Belzer's background. Really? That's what you choose?
For 22 days, so now he has
what
credit
beauty,
for
ambiance.
even more because he's in new paths, and we believe will remain so. At least one of the felonies is a felony retail fraud. This is a misdemeanor retail fraud.
Okay.
And so Mr. Goodstein has indicated he may plead guilty to a disorderly person.
Okay.
And of course, I would ask for time certain.
Okay.
And we can close this file.
All right. Mr. Fair, we are being offered an amended charge to disorder trial or not to testify at trial. If you decided not the right situation of a trial, and you may be faced with those penalties.
Yes.
Has anybody made any threats or promises to cause you to plead guilty?
No.
No. I'll accept guilty
You're
plea
in
to
court,
disorderly
you know.
conduct. I do see a note, Mr. Watson, I saw 22 days somewhere.
I think it's like 34, 35 days at this point.
Okay. Order 34 days
Scrappy
jail,
lawyer.
credit for 30, what? Yeah, 34 days and close the file. Okay.
Thank you.
All right, sir. All right, you're welcome.
I'm feeling a little lazy. I don't know what to do with myself when I'm watching too much court. So
You never gave us a ticket, so here's the
let's go
other
to
thing.
Goggins' room.
I did it.
Motion's on.
Jennifer Jackson, Mr. Tosa, I see you there.
Hi, Judge. Hi, Judge. John Tosa, on behalf of Jackson.
Okay, Jennifer Jackson?
She's not, Judge, these are two civil infractions. I'm appearing for her this morning.
Oh, okay.
think-
Have you talked to Mr. Goodstein, I guess?
I have not spoken with him. I'm just trying, at this point, we're just trying to set aside the fault on two civil infractions so we could speak with him and try to resolve these, Judge.
Oh, okay. I'm sorry? Okay. I'll grant motion to set aside the default. Thank you.
Do you have both proposed orders, Judge?
She just handed them to me, actually. Let's see.
Beautiful.
I think
Thank
I
you.
do. Let's see. Yeah, it looks like. Or not to testify. And you have the right to be time and location, taking a piece of merchandise without paying for. Is it true? Wish to plead innocent until proven guilty beyond fight trial or not to testify. Okay. Do you understand that if I accept your guilty plea, you won't have a trial of any kind? Okay, do I'll sign here.
It's one of the
Oh, it didn't record. Oh, you got trolled. I must have been busy at work. Guys, listen up. Be live on Thursday with Mikey the Legend. Of course, I'll be live tomorrow. Make sure you check out Irish Demon. More to come with time serving Irish Demon. Check out Team Skeptic, another one that's going to have a little work together. Make sure everybody, if you can't stand to not have court at 9:30 or 9:55, to head over to KCC Kitchen Court Cases. She's live right now. She's cooking something up in her kitchen. She definitely has, probably doing Judge Kim or some kind of cool TPO. So head over there right now. That's my girl. Guys, you've been served.